My name is Daniel Parker, and at 16, I learned that some people adopt children not out of love, but as an investment opportunity. Standing in the fluorescent-lit office of the Department of Children and Family Services, watching the woman I called Mom hand back my adoption papers like a defective purchase receipt, I had no idea that my entire childhood had been a carefully orchestrated financial scam. The story begins when I was 4 years old, though I wouldn't learn the truth until much later. My birth parents, Michael and Sarah Chin, were killed in a car accident caused by a drunk driver in Portland, Oregon. I survived the crash with minor injuries, but I lost everything. My parents, my home, my identity, and as I would eventually discover, my financial security. The drunk driver who killed my parents was a wealthy tech executive named Robert Morrison. His blood alcohol level was nearly 3 times the legal limit when he ran a red light and slammed into my parents' car. The civil lawsuit that followed resulted in a $400,000 settlement for my parents' wrongful death, money that was supposed to secure my future and honor their memory. But I knew none of this when Linda and George Parker adopted me 6 months after the accident. To my 4-year-old mind, they were salvation from the confusing world of foster care and grief counseling. Linda was a warm, affectionate woman who baked cookies and read bedtime stories. George was a gentle man who taught me to ride a bike and helped with homework. They lived in a modest but comfortable house in Beaverton, Oregon, with a backyard perfect for a young boy to explore. For 12 years, I believed I had been blessed with loving adoptive parents who had chosen me out of pure kindness. Linda worked as a medical receptionist, George was a postal worker, and together they provided what seemed like a stable, caring home. They attended my school events, celebrated my birthdays, and told me regularly that I was wanted and loved. What I didn't understand was that their motivation for adopting me had nothing to do with building a family and everything to do with accessing the $400,000 settlement that came with me. The truth about my adoption began to unravel during my sophomore year of high school. I had always been a good student, but as college applications approached, conversations about my future became increasingly strained. When I expressed interest in attending Oregon State University to study engineering, Linda and George's reactions were telling. "College is expensive," George said, avoiding eye contact. "Maybe you should consider community college first or trade school. Not everyone needs a 4-year degree." "But I have good grades," I protested. "And you always said education was important." Linda looked uncomfortable. "It is important, honey. But we need to be realistic about what we can afford." Their response confused me. While we weren't wealthy, they had always managed to provide for my needs. I had assumed they had been saving for my college education like other parents. Their sudden financial concerns about my future made me wonder if something had changed in our family's circumstances. The first concrete sign that something was wrong came when I overheard a heated argument between Linda and George in their bedroom one night. I was supposed to be asleep, but their raised voices carried through the thin walls of our house. "We can't keep putting this off," George was saying. "He's going to find out eventually." "Not if we're careful," Linda replied. "We just need to get him through high school and then he's on his own." "And what if he asks questions about college funding? What if he wants to see financial records?" "We'll figure something out. We always do." I pressed my ear closer to the wall, trying to understand what they were discussing. What would I find out? What financial records were they worried about? The conversation continued with fragments that made no sense to me at the time. "Should have planned better. The money's gone. Can't undo what we've done." I lay awake the rest of that night, wondering what secret my parents were keeping and why they seemed so worried about my future discoveries. Over the following weeks, I began paying closer attention to my parents' behavior and our family's financial situation. What I noticed was a pattern of expensive purchases that didn't align with their supposed concern about college costs. Linda drove a relatively new Honda Civic that she had purchased 2 years earlier. George had recently bought a Harley-Davidson motorcycle that he claimed was a midlife crisis purchase. They had remodeled the kitchen the previous year, installed a hot tub in the backyard, and taken annual vacations to Hawaii that seemed extravagant for a postal worker and medical receptionist. More puzzling was their attitude toward documentation of my early life. Whenever I asked questions about my adoption, my birth parents, or the circumstances that led me to their family, Linda and George became evasive and uncomfortable. "The past is the past," Linda would say. "What matters is that we're your family now." "Some things are better left alone," George would add. focus on the future, not what you can't change. Their reluctance to discuss my history struck me as odd. Most adoptive families I knew were open about the adoption process and encouraged questions about biological heritage. My parents' secrecy suggested they were hiding something significant. The breakthrough came during spring break of my sophomore year when I decided to research my own adoption records. Oregon had relatively open adoption laws, and at 16, I was old enough to access some basic information about my case. I told Linda and George the first was spending the day at the library working on a research project. Instead, I took the bus to downtown Portland and visited the offices of the Department of Human Services. The social worker who helped me, Mrs. Angela Rodriguez, was sympathetic to my desire to understand my background. She explained that while complete adoption records were sealed until I turned 18, she could provide some general information about my case. Your birth parents died in a car accident when you were 4, she told me, reviewing my file. You were placed in temporary foster care before being adopted by the Parkers 6 months later. Do you know anything about my birth parents? Their names, what they did for work? Mrs. Rodriguez consulted her notes. Michael and Sarah Chin. Your father was an accountant, your mother was a teacher. They lived in Southeast Portland. She paused, looking at something in the file that seemed to concern her. Is everything okay? I asked. I'm just noticing some unusual notations in your case file. There are references to a civil lawsuit and settlement funds, but the details are in sealed documents. My heart began racing. What kind of settlement? I can't provide specifics until you're 18, but it appears there was a wrongful death lawsuit related to your parents' accident. The settlement was placed in trust for your benefit. Settlement funds. Money that belonged to me, derived from my birth parents' death. Money that Linda and George had never mentioned in 16 years of raising me. How much money are we talking about? I asked. Mrs. Rodriguez shook her head. I really can't discuss financial details. But when you turn 18, you'll have access to all records and any remaining trust funds. Remaining trust funds. The phrase echoed in my mind during the bus ride home. If there were remaining funds, that implied some of the money had already been spent. But spent on what? And by whom? That evening I confronted Linda and George with what I had learned. I know about the settlement money, I said as we sat around the dinner table. I know my birth parents died in a car accident and there was a lawsuit. The color drained from both their faces. Linda set down her fork with trembling hands, while George stared at his plate as if it might provide answers. Who told you that? Linda asked, her voice barely a whisper. Does it matter? What matters is that you never told me. There's money from my parents' death that belongs to me, isn't there? George finally looked up, his expression a mixture of guilt and resignation. It's complicated, Daniel. How is it complicated? Either there's money that belongs to me or there isn't. Linda reached across the table as if to take my hand, but I pulled away. Honey, we used that money to raise you. To provide for your needs all these years. What do you mean you used it? The settlement was $400,000. George said quietly. It was placed in trust with us as trustees to use for your care and upbringing. I felt like the ground was shifting beneath me. $400,000. A sum that could have paid for college, graduate school, and provided financial security for years to come. Where is it now? I demanded. The silence that followed told me everything I needed to know. It's gone, Linda admitted. We spent it over the years on your expenses, food, clothing, medical care, housing. But I had been doing math in my head. Even generous estimates of my childhood expenses wouldn't account for $400,000 over 12 years. Unless they had been including their own lifestyle improvements as my expenses. The kitchen remodel was for my benefit? I asked sarcastically. The hot tub? Your car? Dad's motorcycle? We needed those things to provide you with a good home, George said defensively. Everything we did was to create a stable environment for you. You stole my money, I said, the reality finally sinking in. You adopted me to get access to the settlement and then you spent it on yourselves. That's not true, Linda protested, tears starting to flow. We love you. You're our son. If you love me, then where's my college fund? Where's the money that was supposed to secure my future? Neither of them had an answer for that. The weeks following this revelation were the worst of my young life. The people I had trusted and loved had betrayed me in the most fundamental way possible. They had built their comfortable lifestyle on the blood money from my parents' death while telling me it was gone. But worse than the financial betrayal was the existential crisis it created. Had Linda and George ever truly loved me, or had I been nothing more than a ticket to financial security? Every memory of my childhood was now tainted by the knowledge that their affection might have been motivated by money rather than genuine care. I started researching everything I could about adoption fraud and trustee misconduct. What I learned made me sick. There were legal standards for how settlement funds should be managed for minor children. Trustees were required to use the money primarily for the child's benefit and preserve the principal for the child's future. Personal expenses like luxury vehicles and home improvements were explicitly prohibited. Linda and George hadn't just spent my money. They had violated their legal duties as trustees and potentially committed criminal fraud. When I confronted them with this information, their response was to become defensive and controlling rather than apologetic. "You're being ungrateful," Linda said during one heated argument. "We gave you a loving home for 12 years. That's worth more than any amount of money." "A loving home paid for with my parents' death settlement," I replied. "We don't have to justify our decisions to you," George added. "We're still your parents and you'll respect us as such." But their authority over me felt hollow now that I understood their motivations. I began to challenge their rules, question their decisions, and demand accountability for the missing money. I also started getting in touch with Mrs. Rodriguez to understand my legal options. This change in our family dynamic created constant tension. Linda and George seemed unable to adjust to having their actions questioned, while I couldn't pretend that everything was normal after learning about their betrayal. The situation reached a breaking point 3 months after my discovery when I demanded to see financial records showing how my settlement money had been spent. "I want documentation of every dollar," I told them. "I want to see bank statements, receipts, and proof that the money was actually used for my benefit." "You're not entitled to that information," George replied. "We managed your funds appropriately." "Then prove it. Show me the records." Linda and George exchanged glances that I had learned to recognize as their signal for coordinated deception. "We don't have to prove anything to you," Linda said finally. "You're still a minor and we make the decisions in this family. And when I turn 18? When you turn 18, you can make your own decisions about your life." I realized they were planning to cut me loose the moment I reached legal adulthood, before I could take legal action to recover my money or expose their fraud. They had gotten what they wanted from adopting me, access to $400,000, and now I was becoming a liability. The final months of my time with the Parkers were characterized by escalating conflict and emotional distance. I felt like I was living with strangers who had stolen my identity and my future. They treated me like an ungrateful teenager who didn't appreciate their sacrifices. The end came on a Thursday morning in October, 2 months before my 17th birthday. I had been arguing with Linda about my college plans when she suddenly snapped. "Fine," she said, her voice cold with finality. "If you're so unhappy here, if you think we're such terrible parents, maybe you'd be better off somewhere else." "What's that supposed to mean?" George joined the conversation and I could see they had discussed this option before. "It means maybe this adoption isn't working out for any of us." I stared at them in disbelief. "You're threatening to give me back?" "We're considering all our options," Linda replied. "You're clearly not happy here and frankly we're tired of being treated like criminals in our own home." "You are criminals," I said. "You stole my money and lied about it for 12 years. That was apparently the last straw." The next morning, Linda called Mrs. Rodriguez and requested an emergency meeting to discuss disrupting my adoption. 2 days later, I found myself sitting in the same Department of Human Services office where I had first learned about my settlement money, watching the people who had raised me for 12 years hand back my adoption papers like I was a defective product they were returning to the store. "We can't handle him anymore," Linda told Mrs. Rodriguez, not looking at me as she spoke. "He's become impossible to live with. Disrespectful, angry, accusatory. We think he needs professional help that we're not qualified to provide." Mrs. Rodriguez looked confused and concerned. "This is very unusual. Adoption disruptions almost never happen with teenagers who have been in stable placements for over a decade. Daniel has some misconceptions about his trust fund," George explained. "He believes we mismanaged his money, and he's become obsessed with the idea that we owe him something." "Misconceptions?" I couldn't stay silent any longer. You admitted you spent the $400,000 settlement on yourselves. We used appropriate funds for your care and upbringing, Linda corrected. But Daniel seems to think he's entitled to money that was spent raising him. Mrs. Rodriguez was taking notes, her expression growing more troubled as she listened to our exchange. Daniel, is it true that you've been having conflicts with your adoptive parents about financial matters? It's true that I discovered they stole my inheritance and spent it on luxury items for themselves while lying to me about it for 12 years, I replied. The meeting continued for over an hour, with Linda and George painting me as an ungrateful, disturbed teenager who had become impossible to live with since learning about the settlement money. They claimed they had tried everything to help me adjust but that I had become fixated on money that was legitimately spent on my care. I tried to explain the truth, that they had violated their duties as trustees and spent my money on personal luxuries while telling me it was gone. But Mrs. Rodriguez seemed overwhelmed by the complexity of the situation and the competing narratives. In the end, the system that was supposed to protect me sided with the adults who had legal authority over my life. My adoption was officially disrupted, and I was placed back into foster care at age 16, 12 years after Linda and George had taken me home as their son. As I packed my belongings into garbage bags, the same way I had arrived at their house as a 4-year-old, Linda made one final attempt at justification. "We did love you," she said, standing in the doorway of what had been my bedroom. "This isn't easy for us either. If you loved me, you wouldn't have stolen my money and then abandoned me when I found out. We gave you a good childhood," George added. "That should count for something." I looked around the room that had been my sanctuary for 12 years. The bed where Linda had read me stories, the desk where George had helped with homework, the walls covered with achievements and memories that now felt hollow and false. "You gave me a childhood paid for with my parents' blood money," I said. "And now that I know the truth, you're throwing me away like garbage." I walked out of their house carrying 2 bags of possessions and the knowledge that the people who had claimed to love me had been planning to abandon me from the moment I learned about their theft. But what Linda and George didn't realize was that they had made one crucial mistake. By disrupting my adoption, they had lost their legal authority over me and my affairs. At 16, I was old enough to have some control over my future, and I was old enough to seek justice for what they had done to me. The Parkers thought they had solved their problem by getting rid of me before I could take legal action. Instead, they had freed me to pursue the truth about my stolen inheritance and expose their fraud to the world. The 4-year-old boy who had trusted them completely was gone. In his place was a teenager who understood exactly how the world worked and was determined to make them pay for their betrayal. My new foster placement was with the Henderson family in Southeast Portland, a kind but overwhelmed couple who specialized in emergency placements for older teens. Margaret and Tom Henderson had been fostering children for 15 years and had seen every type of family crisis imaginable, but even they were shocked by my story. "Adoption disruptions are extremely rare," Margaret explained on my first night in their home. "Especially for children who have been in stable placements for over a decade. This situation raises serious questions about what really happened." Tom, a retired social worker, was more direct in his assessment. "If what you're telling us is true, your adoptive parents committed serious financial crimes. Trustees have legal obligations that can't be ignored just because they don't like being questioned. The Hendersons gave me something Linda and George never had: validation that my concerns were legitimate and my anger was justified. For the first time in months, I felt like someone believed me and understood the magnitude of what had been done to me. My first priority was gathering evidence of the financial fraud. Mrs. Rodriguez had told me I would have access to complete records when I turned 18, but I couldn't wait 2 years to begin building my case. I needed to start documenting everything immediately while the trail was still fresh. I started by researching public records that might reveal information about the settlement and how it had been managed. Oregon's court system maintained online databases of civil cases, and with some persistence, I was able to locate the wrongful death lawsuit filed on behalf of my birth parents. The case files were sobering to read. The police report described how Robert Morrison, intoxicated and driving at excessive speed, had run a red light and slammed into my parents' Honda Accord. My father died instantly from massive head trauma. My mother lived long enough to be transported to the hospital but died during emergency surgery. I survived because I was strapped into a car seat in the back, protected by the car's safety features and my parents' bodies absorbing the impact. According to medical records, I suffered a broken arm and multiple bruises but no permanent physical damage. The lawsuit that followed was straightforward. Morrison's blood alcohol content was 0.24, 3 times the legal limit. He had been drinking at a corporate event and chose to drive home despite being offered alternative transportation. His insurance company settled quickly to avoid a public trial that would have generated even more negative publicity. The settlement agreement specified that $400,000 would be placed in trust for my benefit, with my adoptive parents serving as trustees responsible for managing the funds for the child's care, education, and future welfare. The money was to be invested conservatively and preserved primarily for my use as an adult. Most importantly, the trustees were required to maintain detailed records of all expenditures and provide annual accounting reports to the court. These reports should have documented exactly how every dollar was spent and demonstrated that the money was being used appropriately. I requested copies of these annual reports from the court clerk's office, expecting to find evidence of the Parkers' financial mismanagement. What I discovered was even more damning. No reports had ever been filed. For 12 years, Linda and George had been legally required to document their use of my settlement money and submit those reports for court review. They had filed nothing. No expenditure records, no investment statements, no accounting of any kind. This wasn't just poor record-keeping, it was a deliberate violation of their court-ordered duties as trustees. And it suggested they knew their spending couldn't withstand scrutiny. Armed with this information, I contacted Legal Aid Services of Oregon to discuss my options. They assigned my case to attorney Sarah Kim, a specialist in elder financial abuse and trustee misconduct who had experience with cases involving the exploitation of vulnerable individuals. "This is one of the clearest cases of trustee fraud I've ever seen," she told me after reviewing the documentation I had gathered. "Your adoptive parents had explicit legal duties that they completely ignored while spending your money on personal luxuries. What can we do about it?" "Several things. First, we can file a motion with the court to remove them as trustees and demand a complete accounting of the missing funds. Second, we can pursue civil litigation to recover the money they stole. Third, depending on what we discover, there may be grounds for criminal charges." Sarah explained that Oregon law provided strong protections for beneficiaries of trust funds, especially when trustees had violated their fiduciary duties. The penalties for trustee misconduct included not just repayment of misappropriated funds, but also interest, penalties, and potential liability for the trustee's personal assets. "They can't just claim they spent your money on raising you," she continued. "Trustees are required to use trust funds conservatively and primarily for the beneficiary's future benefit. Personal luxuries like motorcycles and hot tubs are explicitly prohibited expenses. But building a strong case would require detailed financial records that I didn't have access to. We needed bank statements, credit card records, and documentation of major purchases to prove exactly how the money had been spent. That's where the Hendersons proved invaluable. Tom's background in social work had given him connections throughout the child welfare system, and he knew how to navigate bureaucratic obstacles that might have stopped me. "We're going to help you get justice," Margaret told me one evening after dinner. "What happened to you is unconscionable, and the people responsible need to face consequences." Through Tom's contacts, we were able to expedite my access to some adoption records that normally wouldn't be available until I turned 18. These files contained copies of financial documents that Linda and George had submitted during the adoption process, including bank statements showing the initial deposit of my settlement money. The records revealed that the $400,000 had been placed in a savings account at First National Bank of Oregon in November 2007, 6 months after my adoption was finalized. The account was titled Daniel Chin Parker Trust Fund, with Linda and George listed as co-trustees. But subsequent bank statements, which we obtained through a legal subpoena, told a very different story. Rather than being invested conservatively for my future, the money had been systematically withdrawn over the following years to fund the Parkers' lifestyle improvements. The spending pattern was clear and damning. December 2007, $35,000 withdrawal for kitchen renovation. March 2008, $12,000 for Linda's Honda Civic down payment. August 2008, $8,000 for Hawaii vacation. October 2009, $15,000 for George's Harley-Davidson. June 2010, $18,000 for backyard hot tub and landscaping. Multiple smaller withdrawals for furniture, electronics, and luxury items. By 2015, the account balance had dwindled to less than $25,000. By the time I discovered the truth in 2023, only $3,200 remained, not enough to buy textbooks for a single semester of college. This is systematic theft, Sarah explained as we reviewed the financial records. They treated your settlement money like their personal bank account while telling you it had been spent on your care. The evidence was overwhelming, but I wanted to understand the full scope of their deception. I began researching the actual costs of raising a child to compare against their claims that $400,000 had been necessary for my care. According to USDA estimates, the total cost of raising a child from birth to age 18 was approximately $230,000 for middle-income families. Since I had been adopted at age 4 and was now 16, the Parkers had been responsible for my care for only 12 years, roughly 2/3 of a childhood. Even using generous estimates that included housing, food, clothing, medical care, education, and childcare, the legitimate costs of raising me should have been no more than $180,000. And that was assuming they had borne all expenses themselves without any assistance from state adoption subsidies or other support. The math was clear. The Parkers had stolen at least $220,000 of my settlement money for their personal use while maintaining the legal fiction that they were acting in my best interests. But beyond the financial fraud, I was discovering an even more disturbing truth about my adoption. Through records requests and interviews with people involved in my case, I learned that Linda and George had specifically sought to adopt a child who came with a substantial trust fund. Mrs. Rodriguez, who had handled my original placement, reluctantly confirmed this when I pressed her for details about the adoption process. The Parkers expressed strong interest in your case specifically after learning about the settlement, she admitted. At the time, we thought they were just being realistic about the financial responsibilities of adoption. Did other families want to adopt me? She hesitated before answering. Yes. There were several families interested in adopting you. But the Parkers were very persistent, and they seemed financially stable and committed to your welfare. What she didn't say, but what I had pieced together from other sources, was that Linda and George had deliberately targeted children with trust funds or other financial assets. I wasn't their first attempt. They had previously inquired about adopting other children who had inheritance money, but those placements hadn't worked out. I was essentially a financial transaction disguised as a family placement. This revelation was devastating on a personal level, but it also strengthened my legal case. If I could prove that the Parkers had adopted me specifically to access my settlement money, it would demonstrate that their fraud had been premeditated rather than opportunistic. Working with Sarah Kim, I filed a comprehensive legal action against Linda and George in December 2023, 2 months after being returned to foster care. The lawsuit included multiple claims: breach of fiduciary duty as trustees, conversion and theft of trust fund assets, fraud in the adoption process, intentional infliction of emotional distress, violation of Oregon's elder financial abuse statutes. We also filed a motion requesting that the court freeze the Parkers' assets to prevent them from hiding money or transferring property to avoid judgment. The response from Linda and George was swift and predictable. They hired an expensive attorney and claimed that all trust fund expenditures had been legitimate costs of raising me. They portrayed themselves as loving parents who had sacrificed to provide me with a good home, only to be attacked by an ungrateful teenager who didn't understand the real costs of childcare. Their attorney, Robert Walsh, filed a motion to dismiss our lawsuit, arguing that the statute of limitations had expired and that my claims were barred because Linda and George had acted in good faith as my legal guardians. But Sarah had anticipated these defenses. The statute of limitations didn't begin running until I discovered the fraud, which had only happened a few months earlier. And the good faith defense was undermined by their failure to file required accounting reports and their systematic use of trust money for personal luxuries. More importantly, we had evidence that their fraud was ongoing. As recently as 2022, they had withdrawn money from my depleted trust account to pay for George's motorcycle maintenance, claiming it was a transportation expense necessary for my care. The court scheduled a hearing for February 2024 to consider both our motion to freeze assets and their motion to dismiss. In preparation for this hearing, Sarah arranged for expert testimony from financial professionals who would explain how trustees are supposed to manage trust funds and why the Parkers' conduct was inexcusable. But I wanted to do more than just win a legal victory. I wanted to expose what had happened to me so that other children wouldn't fall victim to similar schemes. Through my research, I had discovered that adoption-related financial fraud was more common than most people realized. Unscrupulous individuals sometimes targeted children with trust funds, inheritance money, or Social Security survivor benefits, adopting them specifically to gain access to those funds. The system had few safeguards to prevent this type of exploitation. Social workers conducting home studies focused on emotional and practical readiness for adoption, not financial motivations. Court oversight of trust funds was minimal, relying on trustees to self-report their activities honestly. I began documenting my story in detail, creating a comprehensive record of how the fraud had occurred and what warning signs might have been missed. I also reached out to advocacy organizations that worked on behalf of adopted children and foster youth. One organization, the National Center for Youth Law, was particularly interested in my case because it highlighted systemic failures in how trust funds for minor children were monitored and protected. Your case could lead to important reforms in how adoption agencies screen prospective parents and how courts oversee trust fund management, explained attorney Maria Santos, who worked on policy issues for the organization. What kind of reforms? Better financial background checks for adoptive parents, mandatory training on fiduciary duties, regular court reviews of trust fund management, and penalties for agencies that fail to detect financial exploitation. The possibility that my suffering might prevent other children from experiencing similar betrayals gave me additional motivation to pursue the case aggressively, even when the legal process became overwhelming and emotionally draining. Living in foster care while fighting my former adoptive parents in court was one of the most challenging periods of my life. The Henderson family provided emotional support and stability, but I struggled with trust issues and depression that made it difficult to focus on school and planning for my future. I was also dealing with financial stress. The Parkers had stolen my college fund, and I had no resources to pay for higher education. I qualified for some financial aid as a foster youth, but the amounts were modest compared to what I would have had if my settlement money had been properly managed. Sarah Kim was working on a contingency fee basis, meaning she wouldn't be paid unless we won the case. But even with free legal representation, there were costs associated with the litigation. Expert witnesses, document processing, court fees, that strained the Henderson family's limited resources. The emotional toll was even greater than the financial burden. Every court filing, every legal document, every conversation with attorneys was a reminder of how thoroughly I had been betrayed by the people who claimed to love me. There were nights when I lay awake wondering if I should just accept what had happened and try to move on with my life. The legal process was consuming enormous amounts of time and energy that I could have been using to focus on my education and future goals. But every time I considered giving up, I remembered the casual way Linda had handed back my adoption papers, as if I were a defective product being returned to the store. I remembered George's claim that providing me with a good childhood should somehow excuse their theft of my inheritance. And I remembered the 16-year-old version of myself, standing in that social services office, learning for the first time that his entire family had been built on a foundation of financial fraud. That boy deserved justice. The other children who might fall victim to similar schemes deserved protection. And Linda and George Parker deserved to face consequences for their calculated betrayal of a child who had trusted them completely. As the court date approached, I felt ready to tell my story to a judge and demand accountability from the people who had stolen my past and my future. The courtroom was smaller than I had expected, but the weight of the moment made it feel enormous. Judge Patricia Hawkins presided from the bench, her expression serious as she reviewed the extensive case files spread before her. To my left sat Sarah Kim, organized and confident. Across the aisle, Linda and George Parker sat with their attorney, Robert Walsh, looking older and more defeated than I remembered. This was the first time I had seen my former adoptive parents since the day they returned me to social services 4 months earlier. Linda kept glancing in my direction with what might have been regret, while George stared straight ahead, his jaw set in the stubborn expression I knew well from childhood arguments. This is a complex case involving serious allegations of trustee misconduct and financial exploitation of a minor, Judge Hawkins began. I've reviewed the preliminary evidence and I must say, the documentation raises troubling questions about the management of the plaintiff's trust fund. Sarah stood to present our case, her voice clear and confident as she outlined the evidence we had gathered. Your Honor, this case represents one of the most egregious examples of trustee fraud I have encountered in my practice. The defendants adopted Daniel Chin Parker specifically to gain access to his $400,000 wrongful death settlement, then systematically stole that money over 12 years while claiming it was being used for his care. She presented a timeline of the Parkers' spending, complete with bank records, purchase receipts, and photographs of the luxury items they had bought with my money. The evidence shows that defendants spent over $220,000 of trust funds on personal luxuries including kitchen renovations, motorcycles, hot tubs, and luxury vacations. Meanwhile, they failed to file a single required accounting report in 12 years, violating their court-ordered duties as trustees. Judge Hawkins studied the financial records with obvious dismay. Mr. Walsh, how do your clients explain these expenditures? Robert Walsh stood, clearly uncomfortable with the evidence he had to defend. Your Honor, my clients maintain that all expenditures were legitimate costs associated with providing Daniel with a loving home and proper care. Raising a child requires significant investment in housing, food, transportation, and family activities. Mr. Walsh, Judge Hawkins interrupted, I see expenditures here for a $15,000 motorcycle, a $35,000 kitchen renovation, and multiple luxury vacations. How exactly do these benefit the child? The motorcycle provided reliable transportation for family activities. The kitchen renovation improved the home environment where Daniel was being raised. The vacations provided important family bonding experiences. Sarah rose for her rebuttal. Your Honor, trustees have specific legal obligations that cannot be satisfied by creative rationalizations. Trust funds must be managed primarily for the beneficiary's future benefit, not converted into lifestyle improvements for the trustees. She presented testimony from Dr. Amanda Foster, a financial expert who had analyzed the Parkers' spending patterns. Based on standard calculations for child-rearing costs, Dr. Foster explained, the legitimate expenses for raising Daniel from age 4 to 16 should have been approximately $140,000 to $180,000, including housing, food, clothing, medical care, and education. The defendants spent more than twice that amount, with the excess going entirely to personal luxuries that provided no benefit to the child. But the most damaging testimony came from Mrs. Rodriguez, the social worker who had handled my original adoption placement. Under oath, she revealed details about the Parkers' adoption process that had been hidden from me for years. The defendants specifically inquired about children who had trust funds or settlement money, she testified reluctantly. They expressed particular interest in Daniel's case after learning about the size of his settlement. At the time, we interpreted this as financial responsibility, but in retrospect, their motivations appear to have been different. Judge Hawkins leaned forward. Are you saying the defendants targeted this child specifically because of his financial assets? That appears to be the case, Your Honor. They had previously inquired about adopting other children with inheritance money, but those placements didn't proceed. The revelation that I had been targeted for adoption because of my money rather than loved for who I was hit me like a physical blow, even though I had suspected it. Hearing it confirmed under oath made the betrayal feel fresh and devastating all over again. Robert Walsh attempted to minimize this testimony by arguing that the Parkers' interest in financial matters was simply practical planning, but Judge Hawkins seemed unimpressed by these explanations. The court also heard testimony from Margaret and Tom Henderson about my condition when I was returned to foster care at age 16. Daniel was devastated and confused, Margaret testified. He couldn't understand how the people who had raised him could abandon him simply for asking questions about money that belonged to him. The psychological impact of this betrayal has been severe. When it came time for Linda and George to testify in their own defense, their explanations were weak and contradictory. Linda took the stand first, clearly nervous as Sarah questioned her about specific expenditures from my trust fund. Mrs. Parker, can you explain how purchasing a $15,000 motorcycle benefited Daniel's care and upbringing? George needed reliable transportation to take Daniel to activities and appointments. But the family already owned 2 cars, correct? Yes, but... And the motorcycle was a recreational vehicle that Daniel was not allowed to ride due to safety concerns? Linda struggled to answer. It was for family use. Mrs. Parker, did you ever consider that spending Daniel's inheritance money on luxury items might be inappropriate? Everything we did was to provide Daniel with a good home. Including the $18,000 hot tub that was installed in your backyard? That was for the family's enjoyment and relaxation. Paid for with money intended to secure Daniel's future? Linda's composure began to crack. We loved Daniel. Everything we did was because we loved him. George's testimony was even worse. When confronted with the systematic pattern of spending, he became defensive and hostile. Mr. Parker, why did you never file the required annual accounting reports with the court? We didn't know we were supposed to do that. Sarah presented him with copies of the court orders that explicitly required annual reports. These documents were provided to you when you became trustees. They clearly state your reporting obligations. George studied the papers, his face reddening. We must have missed that. For 12 consecutive years? We were busy raising a child. Too busy to comply with court orders regarding the management of his money? We managed his money fine. Mr. Parker, how do you explain the fact that a $400,000 trust fund intended to secure Daniel's future has been reduced to $3,200? George's anger finally erupted. We gave that boy everything. A good home, food, clothes, education. We loved him like our own son. If he can't appreciate that, if he's going to sue us over money, then maybe we made a mistake adopting him in the first place. The courtroom fell silent. Judge Hawkins stared at George with obvious displeasure. Mr. Parker, are you suggesting that providing basic care to an adopted child justifies stealing his inheritance money? George realized he had made a mistake, but the damage was done. That's not what I meant. But it was exactly what he had meant, and everyone in the courtroom knew it. When the testimony concluded, Judge Hawkins took a brief recess before delivering her ruling. I sat in the hallway with Sarah and the Hendersons, trying to process everything I had heard. How do you think it went? I asked Sarah. Their own testimony destroyed their case, she replied. When George said maybe they made a mistake adopting you, he essentially admitted that their love was conditional on your gratitude for their theft. 20 minutes later, we reconvened for Judge Hawkins' decision. This court has rarely seen such a clear-cut case of trustee misconduct and financial exploitation, she began. The defendants were entrusted with managing substantial funds for a child's benefit, and they systematically violated that trust for their own personal gain. She outlined her findings methodically. First, the defendants failed to comply with court-ordered reporting requirements for 12 consecutive years, demonstrating a deliberate disregard for their legal obligations. Second, they spent trust funds on personal luxuries that provided no benefit to the beneficiary, in clear violation of their fiduciary duties. Third, they targeted the plaintiff for adoption specifically because of his financial assets, treating him as a source of income rather than a child in need of a loving home. Fourth, when confronted with evidence of their misconduct, they abandoned the child rather than accept accountability for their actions. Judge Hawkins paused, allowing the weight of her words to settle over the courtroom. The court finds the defendants liable for breach of fiduciary duty, conversion, fraud, and intentional infliction of emotional distress. They are hereby ordered to repay the full amount of misappropriated trust funds, plus interest and penalties, totaling $547,000. I felt a surge of vindication mixed with relief. The judge had understood exactly what had happened and was holding Linda and George accountable for their crimes. But Judge Hawkins wasn't finished. Additionally, this court is referring this case to the district attorney's office for investigation of potential criminal charges. The defendant's conduct appears to constitute theft, fraud, and exploitation of a vulnerable person under Oregon law. Linda began crying audibly while George sat in stunned silence. The reality that they might face criminal prosecution in addition to the civil judgment was clearly overwhelming. Furthermore, the judge continued, this court finds the defendant's treatment of the plaintiff after he discovered their fraud to be particularly reprehensible. Abandoning a child for questioning the theft of his inheritance demonstrates a complete absence of genuine parental love or concern. She addressed me directly for the first time during the proceedings. Daniel, I want you to know that what happened to you was not your fault. You deserved parents who would protect and nurture your future, not exploit it for their own benefit. This court hopes that justice being served will help you heal from this betrayal and move forward with your life. The emotional weight of her words, combined with the relief of finally being believed and vindicated, overwhelmed me completely. I broke down crying in the courtroom, feeling simultaneously vindicated and devastated by the formal confirmation of my family's betrayal. After the hearing, Linda approached me in the hallway, her face streaked with tears. Daniel, please, she said, reaching toward me. We did love you. Maybe we made mistakes with the money, but we genuinely loved you. I looked at the woman who had read me bedtime stories, baked birthday cakes, and comforted me through childhood fears. The same woman who had stolen my inheritance and abandoned me when I discovered the truth. If you loved me, I said quietly, you wouldn't have spent my parents' death settlement on luxury items for yourselves. And you definitely wouldn't have thrown me away when I found out. We can work this out as a family, she pleaded. We can pay the money back and try to rebuild our relationship. We're not a family, I replied. We never were. I was just a financial opportunity that you exploited for 12 years. George joined the conversation, his expression hard and unrepentant even in defeat. You ungrateful little, he started, but Tom Henderson stepped between us. That's enough, Tom said firmly. You've done enough damage to this boy. As the Parkers walked away to consult with their attorney about the judgment and potential criminal charges, I felt a complex mixture of emotions. Justice had been served, but it couldn't undo 12 years of lies or restore the childhood I had lost. The aftermath of the court ruling brought both vindication and new challenges. The Parkers were ordered to pay $547,000 but claimed they didn't have the assets to satisfy the judgment. Their house was mortgaged, George's motorcycle had depreciated significantly, and they had spent most of the stolen money on consumable items like vacations and home improvements. Sarah filed motions to garnish their wages and seize their assets, but recovery would be a long process. In the meantime, I was still living in foster care with minimal resources for college or my future. However, the publicity surrounding my case attracted attention from advocacy organizations and donors who wanted to help. The National Center for Youth Law established a scholarship fund in my name to help other aged-out foster youth pursue higher education. More importantly, my case led to legislative reforms in Oregon requiring better oversight of trust funds for minor children and stricter screening of prospective adoptive parents' financial motivations. 6 months after the court ruling, the district attorney filed criminal charges against Linda and George for theft, fraud, and exploitation of a vulnerable person. They eventually pleaded guilty to reduced charges and received sentences of 3 years probation and community service. As part of their plea agreement, they were required to make restitution payments and attend counseling for financial crimes. They were also placed on a registry preventing them from adopting or fostering children in the future. On my 18th birthday, I aged out of foster care but remained close to the Henderson family, who had provided me with more genuine love and support in 2 years than the Parkers had in 12. Margaret and Tom offered to let me stay with them while attending Portland State University, where I planned to study social work. My goal was to become an advocate for children in similar situations, working to prevent financial exploitation of vulnerable youth and helping survivors of family betrayal rebuild their lives. The settlement money that was eventually recovered, combined with scholarships and financial aid, allowed me to pursue my education without the crushing debt that might have otherwise limited my options. I was finally able to use my parents' legacy for its intended purpose, securing my future and honoring their memory. 3 years after the court case, I received a letter from Linda Parker. She claimed to have found religion in counseling and wanted my forgiveness for what she called our family's mistakes. I read the letter once, then destroyed it without responding. Some betrayals are too fundamental to forgive, and some relationships are too damaged by lies to rebuild. Instead, I focused on building a new life based on truth, justice, and genuine relationships. I graduated college with honors, began working as a child advocate, and eventually started a foundation to help other young people who had been financially exploited by their families. The 4-year-old boy who had trusted Linda and George Parker completely was gone. In his place was a man who understood that family is defined by love and protection, not by legal documents or financial opportunity. My birth parents had died trying to protect me from a drunk driver. My adoptive parents had spent 12 years stealing the legacy my real parents had left behind. But in the end, justice was served, and I was able to build a life that honored both my parents' memory and my own values. Sometimes the worst betrayals teach us the most valuable lessons about trust, resilience, and the difference between genuine love and calculated exploitation. The end. Have you ever discovered that someone you trusted was exploiting you financially? How did you find the courage to seek justice despite the emotional cost? Share your stories of standing up to family financial abuse in the comments below. If this story resonated with you, please like and subscribe to hear more tales of overcoming betrayal and finding justice. Remember, true family protects your future, not profits from your vulnerability. Thank you for following Daniel's journey from abandoned victim to empowered advocate. May we all find the strength to choose truth over comfort and justice over false peace.